The Honorable Judges of the Court of Appeals of the State of Alaska. The Court of Appeals is now in session.
Good afternoon. We are here this afternoon for the argument in Gray v. State, file number A13112. Are the parties ready to proceed?
Yes, Your Honor.
Okay, Mr. Malin, you may begin.
Thank you. Good afternoon. My name is Paul Malin. I am here on behalf of Alan Gray. My plan is to address the middle issues, the prosecutorial misstatement of law as the first one, and then next I would address the implicit element of objectively reasonable fear and the Wyatt case upon which that is based. I also hope to get to the supplemental facts and authority that I discovered while preparing for this argument. This was not your typical assault with a gun case. Luckily, there's a video that shows the incident as it unfolded. Mr. Gray was a passenger in his family van. His wife was present. His uncle was in the back seat. You can hear the sound of an infant as the video plays. Gray was doing nothing wrong. An officer suddenly appeared at his window with a gun. Gray did not know the officer, and he did not know that the officer had received a safety advisory advisement from an incident about 30 days prior, where Mr. Gray had threatened to shoot and kill law enforcement officers. The officer who responded to the car where Gray was sitting was a court services officer. He was not a patrol officer, and he was not involved in the other earlier incident with Gray. Chief Judge, is there something I just noticed you looking at? Okay.
No, sorry, just got to get rid of my email.
Oh, okay, fantastic. So the Officer Pohl did not know Mr. Gray, and Mr. Gray did not know Mr. Pohl. Pohl, however, had a warrant for Mr. Gray. This was not a usual warrant. This was a locate-only, no-contact warrant. So this was in 2016. The officer asked Mr. Gray if he had a weapon, and he said, "Yeah, right here." And he lifted up his coat to show the officer the weapon. Then, in 2016, as now, police were routinely shooting and killing persons of color. Seeing this officer suddenly appear at his window with a gun, Gray feared for his life. He feared that Pohl was going to shoot him. He was upset and angry, and he said, "You shoot me in front of my family, there will be repercussions." Gray could have frozen, done nothing, and in fact, most white educated people probably would have done that because they trust the police. In those few seconds, Gray, sitting in his passenger car, sitting as a passenger in his family van, doing nothing wrong, his life suddenly in danger, and his family present, decided he had to do something. He had to take action to show that he was not a threat, to show that he wanted to de-escalate the situation. In those few seconds, those primal, visceral, and stressful situation that he faced himself, Gray took some surprisingly well thought out actions. Number one, he said, "Look," and he said it twice, "Look, look," and he took the magazine out of the gun. And then he tried to disarm himself. He took the gun and tried to hand it back to his uncle in the back seat. And it was his uncle's gun. The police released the gun to his uncle after they arrested Mr. Gray. When his uncle declined to accept Gray's trying to disarm himself, he took the gun and brought it back to the front of the car. And as you saw in the video, he held it in a peculiar way. I'm sure most of you have seen how the British people drink their tea. They drink it like this. And he held the gun like this, the three fingers up in the air between the thumb and the forefinger. And I'm sure most of you have also watched crime shows where a detective comes into a crime scene, finds a weapon, and how does that officer hold a weapon? He holds it like this, because that is the safest way to hold a gun. What happens next? Gray brings the gun around to the front of the car and places it on the dash. How much time did that take how long did he touch that weapon? From my review of the video, I thought it was at 40 seconds he touched the gun, and at 47 seconds he places it on the dash. Defense counsel below argued it was 5 seconds. The state is asserting it's 21 seconds. In any event, it was a very, very short time that he actually handled that weapon. And he handled it not as a threat, but to show it was not a threat, that he was trying to disarm himself. So his defense was clear. It was based on reason. My conduct in handling that, I'm sorry.
You're mute.
Oh,
Allen. Judge
All
Allen.
right, yes. If I can interrupt you for a second. When he went to put the gun behind him to get to his uncle, wasn't the officer at that point yelling at him to put it on the dash?
Yes.
So he disobeyed the officer's request to put it on the dash and was giving it to someone in the back, who then later says to the officer that he's armed.
Correct.
Okay.
Correct. So anyway, Mr. Gray's defense was based on reason. He argued that my conduct in handling the gun was reasonable conduct. And that the officer...
Sorry to interrupt, Mr. Mayland.
Sure.
So you prefaced your discussion of the video talking about people of color and educated white people and the different reactions they might have. Are you suggesting that that's relevant here? I've watched the video, and are you saying that Mr. Gray is a person of color, and that somehow that's relevant in the discussion here? Is that part of the record other than the video?
Well, he is Native. I'd have to check the pre-sentence report. I believe he certainly appears to be Native to me.
And so are you saying that the fact that he's Native is something that's in the record and that was discussed at the trial court level, or no?
No, I do not think his ethnicity was discussed in the trial. So, I mean, I take my inspiration from Renee Farland, who I know at one of the recent arguments, she mentioned the Alaska Supreme Court letter following the death of George Floyd. And the only reason I would even reference that is simply because of the Alaska Supreme Court's emphasis that people of color have a different reality, and how people respond in different situations sometimes is going to depend on what that reality is. And so while it makes sense for most people who live privileged lives and are educated, it would make most sense for them, and they trust the police, to freeze. That makes sense to them, to freeze, because they're not afraid of the police. On the other hand, the reality of people of color is that they are being killed routinely by police. So to that extent is the only reason I note that Mr. Gray is a person of color and they have a different reality. And as judges, the Alaska Supreme Court emphasized, we need to be, we judges and everyone that's involved in the justice system, need to strive for an awareness of our biases, whether they be conscious or unconscious. I realize I'm getting off the track, so I will.
All right, go ahead, Mr. Mayland.
Try to get back on track here. So again, Mr. Gray's core conduct was based on reasonableness. reasonable, that the jury should evaluate and whether his conduct was reasonable, trying to disarm himself rather than not doing anything at all and just sitting there, or whether the officer's fear was reasonable, given that Mr. Gray's apparently pretty well thought out strategy and action was to show the officer that he was trying to disarm himself, that he was not a threat, and that the officer shouldn't be afraid. Now, of course, the officer, that's all complicated because the state admitted that prior incident with Gray. And so the officer, who's not a street patrol officer, who's a court services officer, goes into the contact thinking that Gray's going to shoot and kill him already. So his awareness, and he said this, his awareness is heightened by virtue of the prior 404B evidence. But Gray doesn't know that. Gray doesn't know that this officer is particularly vulnerable. I mean, this court at one point, I think it was the Cardonas case with Judge Allard, said, you know, it's really typical for Alaskans to have guns, and it's really typical for Alaskans to carry guns in their car. But the point is, Mr. Gray didn't know of that vulnerability of Officer Pohl that he already knew about. Like I said, Officer Pohl didn't respond to the prior incident with Gray. He had never had any contact with Gray at all. And Gray had never had any contact with Pohl. They were complete strangers, as far as I understand. So instead of talking about and arguing about objective reasonableness and whether Mr. Gray's conduct was reasonable under the circumstances, the state's closing argument focused on the subjective evidence of Pohl's fear. And you're well aware of what those arguments were. His eyes got bigger, his voice got higher, his expression, he was speechless, his mouth was frozen, he couldn't find the words. Well, those are subjective qualities. And the state focused on those subjective qualities very effectively, I thought. Now, the state on appeal concedes that the prosecutor's presentation of the elements was, and I quote, incorrect, confused, mistaken, and misstated the law. But nevertheless, it was harmless error. That's at the state's opposition brief at 29 to 31.
So, Mr. Malin, from my understanding of the state's argument, their argument is basically under Wyatt, the idea of the objective reasonableness of the officer's fear is kind of the flip side of whether or not the defendant acted recklessly with regards to the possibility of that fear. And that their position is that while the prosecutor misrepresented the need to find that the officer's fear was reasonable, the prosecutor did not impede or in any way prevent the defense from arguing the recklessly component, and that under Wyatt, if a jury rejects Gray's recklessly argument, then they've also rejected the argument that this isn't reasonable. That's right. That's my understanding of the state's position.
Yeah, I think that's pretty accurate.
So what is your response to that? What is your response to Wyatt essentially says, I mean, was there any sort of impediment of the ability of Mr. Gray to argue the recklessly component or the recklessly element?
Yes, and I think it would be, was going to address that in my second argument on Wyatt, but maybe I can get there through some of the information that I was going to try to argue on this first prong. But I understand the court's question. I think I can get there. Okay. So, but to sum up Mr. Gray's position that it wasn't harmless, the prosecutor's misstatements. So the prosecutor repeatedly distorted the law concerning the elements of assault in the third degree, which undermined the fundamental fairness of his trial. The trial court gave no curative instructions under Adams, and Mr. Gray's defense was at least arguable under Adams, and at least arguable in terms of Your Honor's concurrence in Rossiter, where you made an equivalent to the conviction Rossiter was not a, quote, a foregone conclusion, which I interpret to be, he at least had an arguable defense. So in terms of the misstatements, I guess the factors to consider are, what were the character of the misstatements? Did they undercut the jury consideration of reasonableness? That's under Rossiter and Adams. Were they material and obvious? Second, were the misstatements prominent part of the argument? That's under Adams. Third, as I mentioned previously, was the defense at least arguable? That's under Adams and your concurrence in Rossiter. And finally, what did the trial court do? Did the trial court intervene and clarify any misstatements? Or did the trial court not monitor the closing argument? So in terms of the prosecutor's statement about the objectively reasonable fear implied element, that goes back to the Wyatt case. Prior to trial, in trying to admit Mr. Gray's prior bad act, the state's position was that Mr. Gray's prosecution was all about the reasonableness of the officer's fear. The issue in this case was the officer reasonably placed in fear? One could infer from that reasonably that objectively reasonable fear was a part of the case that the state had to prove. But later during the trial, the prosecutor argued to the jury that you should only consider Officer Pohl's subjective fear, and the jury cannot consider the reasonableness of that fear. The prosecutor stated, "You'll see in the instruction, your question is, was he placed in fear? It's not whether the fear is reasonable." That's at transcript 487, 490 to 491, and Mr. Gray objected to that. That brings us to one of the supplemental facts that I discovered while preparing for this argument. On the first day of trial, the prosecutor filed a proposed instruction that's at the record at 281. And that instruction provides that under Alaska law, quote, a victim's subjective reaction to fear is irrelevant, and gives an example of a subjective reaction as quivering in fear. And the DA proposed this instruction so that the jury would know what fear does not mean. It does not mean quivering. The trial court, however, was not sure why this instruction was needed, and she declined to give it. The point is, the prosecutor knew that under Alaska law, a subjective reaction like quivering was irrelevant, but he nonetheless relied on the equivalence of quivering. In other words, his eyes got bigger, his mouth was frozen, he couldn't speak, his voice went up, as proof, as the best test, as the best evidence of that element of fear. That was what the prosecutor relied on in arguing to the jury. And I see you're going to ask a question, so I'll stop.
So, Mr. Malin, I guess I don't see the connection, because to me, the prosecutor is that instruction is really getting at the difference between apprehension of imminent serious physical injury or death, as opposed to scared of serious physical injury or death. And that instruction, I can see why the judge didn't give it, because it wasn't really at issue in this case. But that the idea is that the macho man who apprehends that he's about to be killed, but nevertheless acts macho, doesn't mean that that's therefore not fear. I mean, that's what that instruction is directed at, which seems to just be different in kind than the separate question of the reasonableness of the fear.
Well, I agree that it's the perception, but the instruction clearly states that quivering is irrelevant to fear. So,
Mr. Malin?
Yes.
Do you think the defense was precluded from arguing about the objective reasonableness of the officer's fear? Because the way I read the defense closing is they seem to be arguing that Gray's conduct didn't contribute to Pohl's fear, that the fear was pre-existing as a result of his knowledge of the officer safety advisement, and that nothing Gray did contributed to the fear, and only kind of reasonableness of the fear by implication. Am I misunderstanding the argument, or do you think the argument was in somehow curtailed by the trial court's ruling during the prosecutor's closing?
Well, that will bring me to another comment the trial court made, and I brought that in relation to a discussion of the state's proposed instruction on reasonable fear. So the defense said, and I was going to get to this in my second part, but I'll just get to it now because it's coming up. The defense said, well, we need to add a line that says, just because someone says they're in fear, that's not reasonable. And the trial court said, well, I'm not going to do that, because if we open that door, we'll be opening that door too wide, which was to me a comment that, you know, we're not going to go to arguing about whether the fear is reasonable, because once we open that door, it's going to be too wide. So I know defense was trying to make that argument and actually made a reasonable argument in its opening, but then the state hammered over and over and over, the question is not the reasonableness of Mr. Gray's conduct. You are not to consider the reasonableness of Gray's conduct in his gun handling. I can provide you with the quotes. So the issue is not, did Gray act reasonably in the way he handled the gun? That's at 497 to 98. Another at 498. As we discussed, it is not whether the defendant acted reasonably with the gun like he did. Another one at 535 transcript. As we discussed, it's not whether the defendant acted reasonably in how he handled the firearm. To me, the argument should have been, if it was to be proper, here's why Mr. Gray's conduct was not reasonable. Not, you as a jury do not consider the reasonableness of his conduct, just as you as a jury do not consider the reasonableness of the officer's fear. It's those arguments go to the core of Mr. Gray's defense, which was reasonableness. Goes to the very heart.
So do I understand that the defendant initially in opening really was defending on this basis of whether the fear was reasonable or not, and then changed gears once there was an objection that was overruled?
That's the way I read the record. That I remember, and I can't put my finger on it right now with a page, but I remember the defense argument was, look, the reason Mr. Gray, that Pohl didn't shoot Mr. Gray, was because he wasn't scared of him. Because his training was, if you think you're going to be fired on, you fire first. And he didn't fire. So, I mean, that was my recollection of the opening. But if I could, again, I think it's plainly wrong for the state to take the issue of reasonable, to argue that the jury shouldn't consider reasonableness, either of one, Gray's conduct in handling the gun, or two, Pohl's fear. And that's what he did. That's what he did. His arguments were, you can't consider Pohl's reasonableness of his fear. You just consider whether he was in fear. And was he in fear? Yes, look at the subjective indicators of his fear. I've already said those. His eyes get bigger, his voice goes up, his mouth, he's speechless, he can't form words. That's how he's in fear. And then as to Mr. Gray's conduct, you're not to consider that. You're not to consider his conduct and how he handled the gun, whether it was reasonable. And when the defense would object, the trial court gave no pertinent instructions whatsoever to explain whether or not this prosecutor was misstating the law. All she did was read the reckless instruction, which in my view isn't clarifying the issues for the jury, which were, well, gee, can we consider whether Gray's gun handling was reasonable? And can we consider whether the officer's fear was reasonable under the circumstances of what does that relate to? Well, whether the officer's fear was reasonable has to relate to what Gray did with the gun. I mean, they're linked. So if if they can't consider whether Gray's gun handling was reasonable, then the officer who walks into the incident already being in fear of serious imminent physical injury because of the prior bad act that was admitted, then a theme that I keep returning to in my brief, Mr. Gray is being held strictly liable because no matter what he did with the gun, the officer's going to be in fear. And the jury never made a specific express determination that that fear was objectively reasonable, and the trial court never instructed the jury that they had to make that finding. Now, kind of brings me back to the reckless instruction where it talks about all these concepts and then says, oh, by the way, of course, if you find that the defendant acted intentionally or knowingly, then he acted recklessly. There was no comparable instruction with respect to this implied element of objectively reasonable fear. In other words, there was no instruction, by the way, if you find Mr. Gray was reckless, you are necessarily also finding that the state met its burden of proof to show beyond a reasonable doubt that the officer's fear was objectively reasonable. That would have kind of cleaned up the record, which was interesting to me getting back to the trial court. The trial court was very, very concerned with having a jury verdict that she said would be, quote, as clean as possible. Guess she didn't want to have to do a retrial, but she didn't investigate, do basic things like, I couldn't find any cases on objectively reasonable fear. And I have a law clerk researching, and the law clerk hasn't found anything. And I don't know if that's an element. I don't know if that's an element that anyone has to prove or not. And it's more confusing than helpful. And you've made your point, let's just move on. I mean, one would think that under those circumstances where crucial elements of the crime and crucial considerations of reasonableness for the jury are being argued in such totally incompatible and opposite ways, that a trial court who is vigilant about instructing the jury correctly is going to say, you know what, these are really hard questions, and I'm afraid we're going to have to take a recess and figure this stuff out so that we can get the jury properly advised about this, because you're saying don't consider anything but whether the officer was put in fear, not whether it was reasonable. And you're saying don't consider the reasonableness of Mr. Gray's gun handling, and the defense is saying the opposite. And this is the whole case. That's the whole case. Okay, so where's my time? Oh my goodness, I only got 3 minutes?
No, you're actually 3 minutes into your rebuttal time.
Oh, okay. Let me try to go very quickly. In terms of the objectively reasonable fear, Mr. Gray's attorney did propose, I mentioned that, did propose an instruction for reasonable fear. So, and the judge declined to do that because once we go that route, we're going to open a door too wide, did not give the instruction. So in terms of the Wyatt inference, I guess, to me, an implied element should be treated the same as a standard element. In other words, this is an element that makes up a crime with its attendant loss of liberty and property and the adverse collateral consequences. Why shouldn't it be treated as the same as a regular element? Why shouldn't the state have to prove that to a jury beyond a reasonable doubt? How can the court imply that from an instruction that jurors who are not trained lawyers probably heard for the first time? And I hate to do this, but I just feel like I have to. Looking at it from the perspective of a juror who's not trained in the law, listening to this for the first time, I have to take a drink of water before I do it. Instruction number 15 at record 223, the source of this inference. A person acts recklessly with respect to a result or a circumstance described by a provision of law defining an offense when the person is aware of and consciously disregards a substantial and unjustifiable risk that the result will occur or that the circumstance exists. The risk must be of such a nature and degree that disregard of it constitutes a gross deviation from the standard of conduct that a reasonable person would observe in the situation. Of course, if a person intentionally or knowingly, then that person acts recklessly. Observation number 1, there is not a specific reference to the victim's objectively reasonable fear. It only talks about a person, which is usually the actor or the defendant. As I mentioned before, there is no accompanying instruction that says, by the way, if you find reckless, you are necessarily and inescapably finding that the state met its burden of proof of proving objectively reasonable fear of the complaining witness beyond a reasonable doubt. I keep trying to think of words to match the disconnect.
Mr. Mayor, isn't the issue with Wyatt is that Wyatt says essentially this objective fear element, which was under common law, has been encompassed by the recklessly, and so that they don't need. I mean, you say they need to be instructed that they're necessarily finding objective reasonableness, but isn't the reasoning of Wyatt that by finding that he acted recklessly, they don't need to be instructed in that. There is no way for Mr. Gray to have acted recklessly without also meaning that the officer's fear was reasonable.
Right. I know. I agree with you that that's what it says. I disagree whether that is plainly, intuitively obvious, a seamless transition, and inescapable conclusion for jurors sitting on a criminal case, and probably hearing this definition for the first time. The best example is the trial court, who had 31 years of experience as a criminal superior court judge, who was reading the recklessness instruction over and over and analyzing it, thinking about it, having her law clerk research it. It wasn't obvious to her. Oh my goodness. How can we rationally and logically say this is going to be universally evident and so clear to a lay jury of 12 people that we can walk out of the courtroom and we can assume, we're confident that those jurors walked out and said, by golly, we found him reckless, and by golly, that means we found beyond a reasonable doubt that the state had proved objectively reasonable fear. If the trial court can't find it, doesn't even see it, says, I don't know if that's an element. It's more confusing to me than not. How can it be a rational inference that jurors are going to make that link? They're going to go through those hoops and they're going to get there, particularly when the last line of that instruction is, of course, if a person acts intentionally or knowingly, he also acts recklessly. Gee, he knowingly touched the gun, or he intentionally touched the gun. No, we don't have to worry about what this says. He's reckless. Anyway, I think you get my point, and I realize I'm running out of time. So the other thing I would like to briefly mention is the state is saying, well, there's no need for a tailored instruction because of the circumstances. There was no request for one, and there's no circumstances that would justify a tailored instruction about objectively reasonable fear. It goes back precisely to the predicament and the unusual character of this case. The officer went into the contact being subjectively afraid because of the prior, so that anything Gray did with the gun would make him liable, no matter how careful he was. And you saw how careful he tried to be. So that underscores the need for an instruction and a jury finding. And the cases, Collins, Dauberkey, all say, well, yes, they may need to prove that. And yes, even if there's enough evidence of that the state did it, the point is the jury wasn't instructed on it, and the jury never made that finding. I understand your interpretation of Wyatt that that's incorporated necessarily. But again, Wyatt is completely different on the facts in terms of, so I would lastly ask the court to limit Wyatt to its facts. I read the briefs in Wyatt. The state made that argument in their opposition brief about this inference, this inescapable inference. And the defendant, Wyatt, didn't file a reply brief. And so it was never questioned. In Peterson, the court allowed the state to, in Peterson, the state requested reconsideration of the Wyatt implied element requirement because they didn't think that made sense, because a bad person who who knows someone is vulnerable because of, say, paranoia could assault that person, but the fear would be unreasonable, and then they would escape liability. So it's Mr. Gray's turn to request reconsideration on the ground that it doesn't make sense because the inference isn't inescapable to a regular panel of jurors. And besides, the facts in Wyatt were so flagrantly aggressive, unlike Gray. Wyatt had a chainsaw. The officer came to the door. He heard a piece of machinery being started up, and he saw the blade of the chainsaw cut through the door, come within 3 to 5 inches of his hand, and then the person behind the door says, "You come in here, I'll cut you up." So those facts are so completely different from the facts in Mr. Gray's case, and there was no prior threat of the same crime that was admitted, putting the officer already in danger. All right, thank you.
Thank you, counsel. Ms. Kleberod?
My name is Teresa Klebrad, and I represent the state of Alaska in this matter. I am going to try to address the many things that have just come up in this argument so far. And one place I would start out with this idea that there is a race issue that we need to look at that is being brought up for the first time on appeal. But if you take it to its logical conclusion that the defendant was situated somewhat differently and he should be treated differently because of his race, we would have to go back to what started out this case 1 month earlier. The logical inference there is that the state should not respond to a call of domestic violence in a case involving people of a different culture or different race. That would be, I think, ridiculous in anybody's mind. I think we have to look at the facts that were actually presented to this officer at the time and the facts as brought about by the defendant. And it started with the defendant threatening the police 1 month earlier, and an officer responding a month later with an arrest warrant that he noticed was outstanding when he happened to come across the defendant.
I have a quick question about that, Ms. Kleberod. Is the arrest warrant, is Mr. Malin correct that the arrest warrant was a locate only, no contact warrant?
I do not know that. That is the first time I have heard that information. The only information I have seen in the record, and I've gone through it I thought thoroughly, was that the police told the defendant 1 month earlier, because he would not cooperate, that they were going to get a warrant for his arrest, and they did in fact get an arrest warrant. I have not heard of it described in any limiting terms. The possibility could exist inside or outside the record. I could have missed something. The police and the testimony all seem to work on the assumption that there was a basis for arresting this defendant, and he was arrested. The next thing I would address would be why we have to hearken back to the defendant's conduct from the beginning. This is not regular 404B evidence of prior misconduct. This conduct had a connection to the case that happened a month later. The defendant made very specific threats to the police. They were a pretty high magnitude. When you tell officers that are there to investigate a domestic violence incident, is it worth dying over? And I will do anything in my power to stop you. That the defendant said that for a reason, to put the officers off so they would not arrest him. When Officer Poole has knowledge of that very specific threat, it bears very much on his reactions at the time, his fear, but it also bears on the defendant's recklessness. To a certain extent, this court can, I think, limit its analysis of his reckless disregard because the trial judge only admitted the evidence of his threat for a limited purpose, and the only evidence of his threat presented to the jury was through Officer Poole's short statement. Officer Trooper Tennis's much longer explanation was made in an offer of proof and wasn't actually presented to the jury. And then the judge changed her mind after the weekend, but Officer Poole had already testified before the weekend as to the statement. And then she changed her mind about Trooper Tennis testifying to the background facts of what had happened there. I argued so much about the reckless disregard on the part of the defendant, though, and the probative nature of that evidence, because that is another reason for upholding the use of that evidence. I feel strongly that because it was evidence of the officer's fear, it was also probative of the defendant's recklessness. The defendant has argued in his brief and today that he had no knowledge of the information in the APSN program. But the point is, he did know, and the judge found that he would have known what the arrest warrant was for, that it harkened back to the incident in which he had made the threat. So therefore, I think there's a reasonable conclusion that can be made that he should be careful in this instance with this arresting officer, because he should be cognizant of the fact that they are afraid of him. The next thing I would argue is the specific details of the APSN report were incredibly relevant and important. They provided the substance of both the officer's fear and the reasonableness of his fear, and also the degree to which Gray was being reckless in continuing to handle the gun when the officer told him not to. It's one thing to gloss over some facts and to say there is an officer safety advisement. What does that tell anyone? It pretty much tells you nothing. It's another thing altogether for an officer to hear that this defendant has threatened to shoot law enforcement if they come into his home. And now this officer is trying to arrest the defendant for the same purpose. So it was necessary to have some information about the substance of that advisement. Details matter. You just don't gloss over the facts because they're uncomfortable. You want to understand the position that witness was in. You don't gloss over the details because they are prejudicial. You don't allow details in only because they're unfairly prejudicial, and that was not this case. Then, sorry, I've taken a lot of notes. As far as the jury instruction goes, I think I would like to make the court aware again, although I did it in my brief as well, to the fact that the judge not only gave the standard instruction, she a couple of times apprised the jury in the trial and after in a written instruction, in corollary instructions to the main substantive instruction, that Officer Pohl's fear had to be reasonable. I think one time she said he had to reasonably perceive a threat of imminent serious physical injury.
Can you give me the citation for that?
Yes. The transcript at 160 to 161 and instruction number 21, which is at the record at 23.
Is that the limiting instruction with respect to the officer safety advisement?
Yes,
Okay.
that is correct. They were limiting instructions. But my point is those all have to be considered together. And the importance of that is that these instructions were contrasted against a bit of confusion at trial. When the prosecutor misspoke, the prosecutor started out the trial seeming to know the correct recklessness standard regarding fear on the part of the victim. He understood that it was a reasonable basis, not an actual or subjective fear. Somewhere towards the end of the trial, he seemed to be confused about that. And the parties objected to each other's arguments in this regard. They had sidebars in front of the jury. Well, with the jury to the side, but the jury was still in the courtroom and they had sidebars with the judge. And it became apparent to the jury that the parties were disputing this. And then the judge twice during closing arguments instructed the jury the things that the lawyers argue about the law or the facts are not necessarily correct. I will provide you with the law. And then she also provided them with a written instruction that said, if the lawyers did not accurately state the law that I provide you, or they misstate the facts, please disregard what they have said.
Ms. Clarebot, isn't the problem here that that's not what a judge is supposed to do? If there's actually a disagreement about the legal basis or whether there's an element, the judge needs to resolve that and say, prosecutor, you're wrong. Defense, you're correct. And do you want me to instruct the jury on the correct law more clearly? I mean, but my understanding, Mr. Malin's argument is that perhaps not having it be an express element is fine in a case where the jury hasn't been led to believe anything but that reasonableness is required, but where the jury has been told aggressively by the prosecutor that the officer's fear does not need to be reasonable, the judge has not said that's wrong, and the only instruction that even references it is the limiting instruction back related to the 404B evidence, that this jury just wouldn't know that this was even something they should be considering.
I would say in a perfect world, that would be quite lovely. The problem is it didn't happen in this case. So we must ask where we go from here. And was this mistake worth believing that the jury did not come to the right results? And I don't think that is the case, because the limiting instructions were both verbal and in writing, and there were multiple of them. And the jury could tell that the prosecutor and defense counsel were fighting about this point of law. It might have been preferable for the judge to do it as you suggested, but she did not. And I think the fact that she did provide the limiting instructions in conjunction with a proper instruction took care of that problem. I would mention one other thing.
You said the limiting instructions in conjunction with the proper instruction. When you say proper instructions, you just mean the elements instruction?
Correct.
Okay.
Do you agree with Mr. Malin that Mr. Gray started off defending more on this issue, and then once his objections didn't go anywhere, he changed gears and gave up this line of argument and changed his argument essentially.
No, I don't think he gave up. What I think he did is he decided he had argued about enough, and his objections and his view was placed on the record, and the record was protected for him to make this argument. And then I think he focused on other things in his argument to the jury, because both parties focused much more on the view of the videotape. I think the audio video recording was really what was controlling here. Even though there was a dispute about this instruction, I don't think it took over that much of the trial, or would have influenced the jury improperly.
Ms. Clarabot, what did the prosecutor argue in terms of what evidence demonstrated that Mr. Gray had acted recklessly?
The prosecutor's primary argument, and I think, was to look at how much fear the defendant put the victim in, but his primary argument was really look at he's handling the gun. The defendant has made it rested very much on the argument that the defendant handled the gun very gingerly, very carefully. But from the prosecutor's point of view and the theory he presented for the jury, this wasn't anything about how or whether how the defendant handled the gun. It was about the fact that he handled the gun at all. And to that extent, I think he has taken some of what happened out of context in one of his arguments. He argued that the prosecutor repeatedly told the jury that this issue was not whether defendant was reasonable in how he handled the gun. And he tried, I think defense counsel has tried to misconstrue the state's argument. The state did argue it's not whether defendant was reasonable in how he handled the gun, but the other corollary to that part of the state's case was the problem was the defendant handled the gun at all.
Isn't the idea of recklessly that the person has to be aware of, subjectively aware that there's a chance, right, that an unreasonable risk that the person's going to be this afraid? And so, and isn't the kind of underlying reasoning of Wyatt that whether couched as recklessly means acting unreasonably or couched as the officer's or the victim's subjective fear is reasonable, that those things kind of are related? I mean, there does seem to be a relationship between the prosecutor saying, I don't have to prove that the officer's fear is reasonable, and the prosecutor's mistaken view that the reasonableness of Mr. Gray's conduct had nothing to do with the recklessly element.
I agree with you that they are intertwined. They're almost kind of separate sides of the same coin, if you will. But in this case, the prosecutor, I believe, argued about the recklessness of the defendant as well. And I don't think his focus on the victim's fear then undercut any aspect of the defendant's recklessness. And I would also say about all the evidence of the victim's subjective fear informs on the issue of whether that fear was reasonable under the circumstance. So there was nothing wrong about talking about the subjective nature of the victim's fear. It was improper to suggest that objective standard didn't apply. I would say one thing. I would pray to the court, though, when we first started argument here, one of the members of the court suggested that the prosecutor misrepresented the law. To me, the use of the word misrepresented or misrepresentation suggests some ill intent on the part of the person doing the misrepresentation. I think the evidence only shows here that somewhere along the line, the prosecutor became mistaken. So I would hope any decision addressing this issue flesh out that issue. I mean, in that regard. The next thing I would say about the jury instructions is I think that Wyatt controls. Today, what defendant is implicitly I think is asking for is Wyatt to be overturned. But I think stare decisis controls that decision. And this is the law that applies to the situation. I don't think that based on Wyatt, the defendant cannot say that plain error occurred here regarding the jury instructions, because the error was not obvious, even though there was some confusion about these elements. Technically, the way the jury was instructed is in accord with Wyatt. And so therefore, I don't think you can say that there was any obvious error. Sorry, if I can just look at my notes a second.
Oh, go ahead.
Again, I would say the defendant suggested things like it would be improper to talk about quivering and other subjective signs of a person's fear. But again, I think subjective signs of a person's fear inform on the objective reasonableness of their fear. And as to defendant's argument that the situation would make it as if a defendant would be held strictly liable, I think for his decisions in the circumstance, I think is absolutely incorrect. The point here is that the officer told the defendant not to handle the gun. Therefore, no matter how defendant handled the gun, it could cause a person to be afraid. From the officer's point of view, when the defendant removed the magazine, he couldn't tell the magazine was being removed because he just could see some touching of the gun and handling and fiddling with the gun, but he couldn't tell what was going on. He did not know that the defendant was not ready to make good on his promise to shoot police if they tried to arrest him. So I think there was an objective, there was lots of evidence that would support a finding that this officer's fear was objectively reasonable, and the jury instructions were consistent in helping the jury decide this on a correct basis in the law when things are all read in their entirety, even with the dispute between the parties regarding the instructions and what the elements were. The jury decided this case based on correct advisements regarding the law. The other thing I would point out to the court is there's one other case that I think that controls here besides Wyatt, and that was the Hodge case, which the defendant cited in, I believe, his opening brief. And I think it goes to the proper admissibility of the threat evidence and kind of controls that outcome. In that case, the police were called to a scene in the valley, I believe, where there was a man threatening people in a home with a gun. When the police got there, the man was no longer in the home, but the police knew that the defendant had been threatening people with a gun. An officer was driving down the road and he came across the defendant in the roadway. He was off in a distance. It was dark. He couldn't see the defendant really well. The defendant kind of turned sideways, had a profile. The officer thought the defendant was pointing something at him, but he couldn't tell what it was. The issue on appeal became a sufficiency of the evidence case. And the court found that the evidence was sufficient to convict the defendant of a third-degree fear assault charge. In coming to that conclusion, the court emphasized or noted the fact that the officer went into the situation knowing about the defendant threatening to kill people with a gun. If it was relevant in that situation to affirming the verdict, I think it shows that the evidence was relevant here and it was properly admitted into evidence. Actually, unless there are further questions, I think I am finished.
Thank you.
Any questions? Mr. Malin, you don't actually have any time left, but we'll go ahead and give you 2 minutes
Oh,
to
perfect.
do rebuttal and finish up.
Thank you. Just briefly, mentioning quiver is okay, but basing your entire case on subjective indications that this court has said are irrelevant to fear is not okay. In terms of curative instructions, Adams is the case that says trial judges need to correct any possible misstatements and instruct the jury about what the misstatements are, particularly when we're talking about elements of crime. The comment that the district attorney's position changed, well, I can't prove motive, and I don't think I have to prove motive, but it certainly is suspicious that as the case progressed and the officer looked at the video and said, to the question, well, where on this video does it show Mr. Gray acting aggressively? Well, I guess it doesn't show that. Strategy changed from that point on. I don't know why, but it's a consideration that I thought. I don't know if it's true or not, but that's the reason he changed, but it's a circumstance of the case. In terms of plain error, Mr. Gray's attorney requested an instruction on objectively reasonable fear. It's not a plain error issue, and he alerted to the court of the problem. In terms of...
When you say you mean the one that you just showed us where he asked for it to be reasonable fear?
Yeah, we got to add a line that says just because someone says they're afraid doesn't mean that's reasonable.
Right.
But he didn't want that instruction, and then he said as a fallback position, but if we keep this
Yeah, if we give it, we have to add a line that the fear has to be reasonable. The Hogg case, I vaguely remember it, and I think in that case, the defendant aggressively chased the complaining witness down the street, which is the opposite of Mr. Gray, who tried to disarm himself. The arrest warrant I have right in front of me, it's plaintiff's exhibit number 2, admitted to the trial court during the evidentiary hearing, and it says, quote, in capital letters, locate only dash no contact.
So the jury wasn't informed of that?
No, and it's not technically an issue in the case because there was no litigation over it, but I was just a little concerned that the officer was having contact with this warrant when the warrant said locate only, they know where he lives, they know his address, they know his car. It's like, no, don't get me started on that. So it's not really relevant. It isn't relevant to the issues on appeal, but it's a fact in the record. In terms of...
Mr. Malin, if you can wrap up in about 30 seconds.
Okay, so my summary on the objectively reasonable fear is that Mr. Gray requested a jury instruction. He objected. He alerted the trial court of the need to have the jury decide this element. An implied element should not be treated any differently from a regular element. Wyatt doesn't control because it has wildly different facts. The inference under Wyatt is not a natural, inescapable, obvious, seamless conclusion that every juror will inescapably draw. The verdict was flawed because the trial court didn't do any instructions. That's the Adams case. I urge the court to look at that closely. That's a fairly recent case. And again, the trial court didn't give the instruction expressly. The jury didn't make the finding expressly. This was structural error under Jordan, which also involved a factor of reasonableness, taking urging the jury to not consider reasonableness, and Gray was essentially held strictly liable. I mean, what if he would have touched the gun to shoot himself? Would that have made him strictly liable? Would he be strictly liable because he touched the gun and he was just going to take himself out? Thank you very much.
Thank you, counsel. Take this matter under advisement and we stand adjourned.